Chapter 18. What is a trademark opposition? A trademark opposition is a challenge by another party to a United States Patent and Trademark Office application. An opposition occurs when a company or an individual believes that its trademark rights would be harmed by the registration of an application pending at the USPTO, and they file to block it. The most common basis for an opposition is a likelihood of confusion between the opposer's trademark and the pending application. An opposition may be filed when a pending application receives preliminary approval from the USPTO and is then published in the USPTO's official records, called the Official Gazette. In an opposition proceeding based on an alleged likelihood of confusion, the opposer must establish that its rights to the trademark predate those of the challenged applicant, and that the opposer's trademark and the applicant's trademark are likely to be confused. Generally, the two main factors in determining whether two marks are likely to be confused are: one, the similarity of the two names in sound, appearance, and meaning, and two, the similarity or relatedness of the goods and services when used in connection with the trademarks of the applicant and the opposer. A party who receives a notice of opposition to its trademark application generally has 40 days to file an answer. To best prepare an answer and plan a strong defense, you should contact an attorney immediately if you receive a notice of opposition. A notice of opposition is a trial conducted mostly via paper and online communications before a panel of 3 judges of the Trademark Trial and Appeal Board, or TTAB, which is an administrative panel that is part of the USPTO. Following the submission of an answer, the parties generally exchange interrogatory questions and requests for documents to be produced by each side in the dispute. The opposition process frequently includes depositions and motions as well. Many opposition cases are settled among the parties or otherwise resolved, but in those that are not, the parties will eventually submit final briefs to the judges, who will then make a ruling. Opposition proceedings are governed by the Trademark Trial and Appeal Board Manual of Procedure, or TBMP, which is several hundred pages long and can be quite extensive in detail due to the nature of the legal correspondence and evidence required in the proceeding. The entire process, believe it or not, can take 2 years or even longer. For all of these reasons, it is strongly recommended that a party in an opposition matter, whether on the plaintiff's side or the defendant's side, use an experienced trademark attorney.